Today our goal is to give you as much information as we can and to review the Canadian employment environment and highlight some pretty big changes that were made in 2018. Our topics today include employer payroll taxes and remittances, employee leaves and how to pay employees in accordance with employment standards, drug and alcohol testing in Canada, public health care versus employer-sponsored group benefit plans, employment agreements, how to end the employment relationship, some anti-harassment legislation and training requirements in Canada, and finally some recruiting trends and employment options in Canada. And again, if we don't cover a topic you're interested in or you have questions, please reach out to us directly for more information. So to start off, many new employers to Canada that we've worked with have mistakenly thought that they're federally regulated by the Canada Labour Code, when in fact only 10% of industries in Canada fall under federal legislation. So I wanted to briefly cover what's governed by provincial versus the federal government. Each province has control over employment standards legislation, so things like minimum wage, vacation pay, leaves, etc. Also workers' compensation boards and health and safety, and the province has control over human rights legislation. In contrast, the federal government has control over employment insurance programs with the exception of Quebec, who administers their own EI program. And for specific industries only, such as banks, air and marine transportation, and telecommunications, the federal government legislates employment standards through the Canada Labour Code and administers workers' comp, and health and safety regulations. The takeaway here is that most of you listening today should refer to the provincial regulations where your employees work, and the rest of today's webcast will apply to provincially regulated companies. It is important to note that each province, like each state, has its own interpretation and laws for employment standards. So now that we're all on the same page in terms of jurisdiction, let's turn to payroll taxes and remittances. So to set up in Canada as an employer, you'll obtain a business number from the Canada Revenue Agency, known as a CRA, and register for a payroll and sales tax account, and you'll need to register with the Provincial Workers' Compensation Board where your employees are working. Once you start to pay your Canadian employees, the payments to be remitted to the CRA include your employer-paid portion of the Canadian Pension Plan, called CPP, which is 4.95% of salary, the employee-paid portion of the CPP, which is the same, 4.95% of salary. You'll remit the employer portion of employment insurance, called EI, to Service Canada, which is 2.324% of salary, and remit the employee-paid portion of EI, which is less than the employer portion at 1.66%. All of these percentages I've mentioned reflect 2018 rates. We may see some changes in 2019, but if there are, they're usually minor. And of course, you'll remit the employee-paid federal and provincial income taxes to the CRA. Some provinces also charge an employer-paid and employee-paid health tax, such as Ontario. As noted on the slide, Quebec administers their own pension and employment insurance plan, so they have slightly different rates, so please reach out if you need more information. The employee's income and deductions are reported on a T4 at year-end, which is similar to the W-2, and in Quebec, you'll also have to report using a relevé that is submitted to Revenue Quebec. For employees who cover their own expenses throughout the year or work from a home office, you'll also provide forms such as the T2200 forms. Next, an important tax to consider if you're doing business in Canada is the goods and services sales tax. This may apply when you sell your services in Canada or when you use a Canadian vendor who is selling you services or products. The federally regulated goods and service tax, known as the GST, is set at 5%, and each province regulates provincial sales and service taxes that may be charged on top of the 5% GST. Some provinces, such as Ontario and Nova Scotia, have what we call harmonized the federal and provincial sales tax into one lump sum called the HST, while other provinces have maintained a separate system for federal GST and their provincial portion of the sales tax. So I won't go through each example I've listed on the slide, since this topic is an entire presentation in itself, but I wanted to just give you a heads up to speak with a financial advisor regarding how the GST, PST, or HST will impact your business in Canada. An experienced accountant can help you look into zero rating categories, meaning you can be exempted from charging or being charged sales tax by your Canadian vendors under certain conditions. In order to be zero rated, you must be considered a non-resident under Canada's Excise Tax Act, meaning you have no permanent establishment in Canada, so no fixed place of business, including a place of management, a branch, an office, or a workshop, or any place of extraction of natural resources. However, you can have an independent agent acting on your behalf in Canada. So for example, if you want to hire a Canadian employee to work from a Canadian home office, you can use the services of an outsourced employer, such as HR Options, without it affecting your non-residency status. And again, I'm happy to refer anyone interested in this topic to a Canadian tax expert if you want to contact me after today's webcast. And with that, I'll pass it over to Stacey, who's going to begin our talk on how to pay your employees in accordance with employment standards legislation in Canada.
Great. Thank you, Catherine. So that's right. Our next topic is pay and hours of work. And first, I'd like to review minimum wage laws in Canada. So some of the lowest rates seen are in Saskatchewan at $10.96 an hour. And one of the highest minimum wages is Ontario, where effective January 1st, 2018, it's $14 an hour, with it increasing to $15 an hour in January 2019. And Alberta following suit and increasing to $15 per hour in October of 2018. So to give examples from some highly populated provinces, the minimum wage in British Columbia is $12.65 an hour, but going up to $13.65 in June 1st of 2019. And it will continue going up each year. And in Quebec, it went up May 1st, 2018 to $12 an hour. So please note the legislative increases listed on the slide. A good resource to keep on top of minimum wage in Canada is the Retail Council of Canada website. So note there are exceptions to minimum wage in most provinces for students or employees serving liquor and home workers, among others. So please see the Provincial Employment Standards Act or code where your employees are actually located to determine if an exemption applies to your staff. So provincial employment standards legislation covers everything from termination requirements to minimum wage, but what I wanted to discuss now is overtime rules. Like most employment standards, overtime does vary per province. So throughout the webinar, we're going to give you examples from across Canada to highlight some of those differences. However, you have to be sure to investigate what applies to your employees by going, like I mentioned, to those provincial websites where your employees are actually working. Generally, the overtime rule is 1.5 times the employee's hourly wage for hours in excess of the weekly or daily maximums. For example, hours worked in excess of 40 hours per week would be considered overtime in British Columbia and Quebec, and 44 hours per week in Alberta and Ontario, anything over 48 in Nova Scotia. So note that Alberta also has daily maximum of 8 hours per day, as well as that weekly maximum of 44 hours. So in this case, you pay overtime on whichever amount of overtime, daily or weekly, would be a greater benefit to the employee. There are also double time rules for employees working more than 12 hours per day in some provinces. If the employee is paid via incentive pay, so piecework or commissions, minimum wage is used to determine overtime pay. Just note that the definition of wages also varies per province when determining the rate of overtime. Some may include vacation pay for overtime, like Saskatchewan, and others don't, like Alberta. Under new Ontario legislation in 2018, employees who hold more than one position with an employer and who are working overtime must be paid at the rate for the position they are working during the overtime period. There's not enough time for me to go over it today, but I'd like you to be aware that there are options if you do require a lot of overtime. You could implement averaging agreements, or you could develop agreements with employees to take overtime off as bank time. So there are other options to paying out overtime if your employees agree to it and you follow the correct employment standard guidelines. In all provinces, overtime applies to full-time, part-time, and student employees. Overtime is also applicable whether the employee is paid hourly or salary. In Canada, we don't regularly use the term exempt versus non-exempt like in the U.S. Rather, most employees are eligible for overtime pay even if they are salaried. The only reason someone wouldn't receive overtime pay is if they meet specific requirements. For example, employees whose job duties qualify them as true managers wouldn't qualify for overtime in Ontario and most other provinces. Exemptions from certain employment standards in Canada are based on what the employee is actually doing, their duties, and not necessarily by their title. I've added some links to this slide for your reference to some special exemption rules to determine if your employees would be considered exempt. If you have employees in another province not listed, feel free to reach out to me for more information. In Ontario and Quebec, overtime does apply to travel hours. All work hours, even travel hours, fall under normal hours of work regulations, where exemptions like we talked about don't apply. Also in Ontario, commuting time and travel during the workday are treated differently under the Employment Standards Act. Commuting time is the time it takes an employee to get to work from home and vice versa. This is not counted as work time for the purposes of the ESA. However, there are a number of exceptions to this rule. So for example, if the employee takes a work vehicle home in the evening at the employer's request, time work begins when the employee leaves home in the morning and ends when he or she arrives home in the evening. Also, if the employee is required to transport other staff or supplies to or from the workplace or work site, that must be counted as work time as well. Next, if the employee has a usual workplace but is required to travel to another location to perform work, the time traveling to and from that other location is counted as work time in both Ontario and Quebec, and in most other provinces. Be careful to check regulations for employees exempt from overtime regulations, such as managers. They are probably eligible to be paid for travel hours, but the overtime calculations don't apply. Again, refer to today's handout to see specific rules in the province that you're interested in. This next slide on public holidays has a lot of information on it, and it's really meant to be a reference for you after today's webcast. Firstly, all statutory, also referred to as public holidays listed on this slide, must be paid to employees under the Employment Standards Act of each province. For each holiday, the slide shows which provinces mandate that you pay for the holiday. However, there are cultural norms and special rules, some of which I've noted directly on the slide, and a couple here that I'll highlight. So for example, Boxing Day, which is the day after Christmas, and the August Civic Holiday are not official statutory holidays in most provinces, but many companies provide it as a paid day off for employees. Also in Quebec, often January 2nd is provided as a holiday as well. So keep in mind, if you choose to honor one of these extra days as an additional holiday for employees, despite the extra day not being officially listed in the employment standards, all rules pertaining to the general holiday pay will apply to that day if you deem it as a holiday for employees. So if they work that holiday, they would be entitled to premium pay. So in regards to payment of holidays, again, it varies per province, but if an employee agrees to work on a public holiday, you generally have to pay them for the day worked and a premium pay of another full day and a half. So for example, an 8-hour day employee would get 8 hours for the day worked on the public holiday and another 1.5 times that day, so another 8 plus 4 hours for a total of 20 hours for the day. Alternatively, with employee consent, you can provide them with another substitute day off work in lieu of the holiday. And of course, depending on the province, you'll have to research that. The new Employment Standards Act legislation in Ontario, effective 2018, did originally change the holiday pay calculation to benefit the employee, but after employer complaints, the Ontario government reversed their decision, and effective July 1st, 2018, the calculation is now back to taking the last 4 weeks of earnings preceding the holiday divided by 20 to get the average wages to pay as holiday pay. This ensures part-time employees receive prorated holiday pay amount. So in terms of who's eligible for paid public holidays, most provinces will list a time period that an employee must have been employed before being eligible for holiday pay. So for example, in British Columbia and Nova Scotia, the employee must have worked 30 calendar days before the holiday and have worked and earned wages in 15 of those 30 days before the holiday. Whereas in Alberta, Ontario, and Quebec, it doesn't matter how long the employee has been with the company, they are entitled to the holiday, but it's prorated based on that last slide that we discussed, those calculations. So many provinces, including Ontario, say the employee must have worked their last scheduled shift before and the first scheduled shift after the holiday to be paid for the holiday. But a word of caution here, be aware that employees will remain eligible for holiday pay if they have the employer's permission to be absent for either or both of those shifts. So for example, because of vacation or sick time. And lastly, to qualify for holiday pay in most provinces, the employee must not have refused to work on the general holiday when asked to do so. Some common jobs that are exempt from holiday pay include agricultural workers, managers, some commissioned salespeople, but again, check your province using the links that we've provided in today's handout to be sure of your situation. And now I'll pass things back to Catherine to discuss vacation pay.
Great. So the most important thing to remember is that vacation time and pay applies to salaried, hourly, full-time, part-time, student, and contract employees. Vacation normally starts at 4% of gross earnings, or 2 weeks per year for a full-time person. Some provinces legislate mandatory increases in vacation, as I've listed on the current slide. But in reality, the norm for many professional positions is to start employees at 3 weeks per year. So please keep this in mind when recruiting if you want to remain competitive. How vacation is paid can often be a source of confusion to companies in Canada. Vacation rules and exemptions varies per province, but to highlight a common example, I'll use Ontario, whose legislation is comparable to the other provinces. In Ontario, the legislation covers vacation time and vacation pay. For vacation time, employees are entitled to 2 weeks time off after 12 months of work. But keep in mind that the norm is to allow time to be used as it is accrued. In addition to that time off, employees are entitled to at least 4% of their gross wages earned in the last 12 months paid as vacation pay. It's important to note that gross wages may include regular pay, bonuses, public holiday pay, commissions, overtime, termination pay, etc. Check which province your employees are in to determine the definition of gross wages. At least 4% vacation pay should be paid on all these types of compensation. To make your life easier, many companies pay employees through their vacation and track it, as well as pay their 4% on any additional payments, such as bonuses and commissions, at the time of payment, so that you know that by year end, you've met all the legislation. Lastly, remember that you must pay out all accrued and unused vacation to a terminated employee up to and including their last day of work. Next, we often get asked if it's normal in Canada to allow employees to fall into a negative vacation accrual. So for example, if an employee has only worked for 6 months but asked for their full 2 weeks of vacation time off. In this case, the employee would fall 1 week into a negative accrual and not quote unquote climb their way out of that negative accrual until year end. In truth, for professional level positions, many employers allow negative accruals and trust that the employee's accrued time will balance out. However, if you're a company that experiences high turnover, I would not recommend allowing negative accruals, since it's normally not allowed in Canada to deduct any funds from an employee's pay, including negative vacation accruals. A practical solution is to implement a negative accrual cap. For example, your policy can state that with management approval, and if it does not interfere with workflow, employees are entitled to fall into a negative vacation accrual of no more than 5 days before vacation requests will be denied until vacation days are accumulated. To answer another common question, you can carry vacation accruals to a new year, and you can cap vacation accruals, so long as the cap does not interfere with the employee receiving their minimum vacation entitlement under employment standards laws or whatever is written in the employee's employment contract. Lastly, it's important to know that employees on unpaid protected leaves of absence, such as sick leave or maternity leave, will continue to accrue seniority and unpaid vacation time. However, they would normally not be entitled to vacation pay for that time on unpaid leave. It's important to be very careful how you word your vacation policy and how you outline vacation pay in your employment agreements. If you indicate that employees are entitled to a flat 2 weeks paid vacation each year, and you do not link vacation pay to their accrued earnings, you may have an employee on a long-term leave asking for their 2 weeks of paid vacation despite the fact that they have no earnings, and in this case, they would be entitled to that pay. Instead, word your policy along the lines of, you will be entitled to 2 weeks or 10 days vacation time per year earned at an accrual rate of 3.08 hours for every biweekly cycle actively worked. So of course that example would be tailored to your organization and how much vacation they're getting. Now I'm going to take you through job-protected leaves of absence in Canada. When I say job-protected leaves, I mean eligible leaves that fall under human rights and/or employment standards legislation that an employer must allow employees to take. However, keep in mind that the employer is not required to pay the employee throughout the leave. So this slide highlights some protected leaves for your reference, but I'll be specifically reviewing with you pregnancy and parental leave, compassionate care, and some special leaves in Ontario. Before I get into my specific examples, human rights legislation gives 3 specific rights to employees on protected leave. One is the right to reinstatement after their leave to the same job or comparable job if that same job no longer exists, and the right to the same pay or increased pay if it went up while the employee was on leave. The right to be free from penalty or discrimination for taking the leave, so penalty or discrimination by the employer, and the right to continue to participate in benefit plans while on the leave. So for example, pension plans and extended health and dental, etc. The first leave I'll review with you is pregnancy leave, which I know always surprises our U.S. listeners. As usual, leave legislation varies per province, and in this case, Quebec is the most generous, but effective 2018, Ontario and Alberta are also offering a lot more time off for parental leave. In general, pregnant mothers can take between 15 and 18 weeks unpaid pregnancy leave, and on top of this, 35 to 37 weeks unpaid parental leave, so generally 52 weeks total leave. However, in Quebec, mothers can take up to 52 weeks unpaid parental leave on top of their pregnancy leave, and effective 2018, in Alberta, mothers can take up to 62 weeks parental leave, and Ontario, mothers can take up to 61 weeks of parental leave. Fathers, adoptive parents, guardians do not get the 15 to 18 weeks pregnancy leave, but they can take up to 37 weeks unpaid parental leave. And again, in Quebec, this parental leave can extend to 52 weeks, in Alberta to 62 weeks, and in Ontario to 63 weeks. Quebec also grants fathers 5 weeks unpaid paternity leave on top of the parental leave. So to qualify, employees must be covered by employment standards legislation, which 99% of you who are listening today would qualify under. An example of an employer exempt from employment standards would be law firms who are self-regulated. Also, to qualify, generally an employee has to be hired for a specific time frame before the start of the leave. However, please note that the employee does not have to actively work that time frame before the start of the leave. For example, they can be off on sick time, and this would count as active work. A final note of interest here is that since the leave is not paid by the employer, employees taking this leave and any other leave that falls under employment standards receive employment insurance benefits, or EI, from the government, which for maternity leave is approximately 55% of the employee's salary to a maximum of approximately $547 gross per week for the 52-week period. And again, the formula will be a little different in Quebec, Ontario, and Alberta, where they've extended and offered more time for leave in those provinces. So you don't have to pay your employee while they're on the leave, but what do you have to do as the employer? As the employer, you have to provide an employee going on leave with their record of employment, known as their ROE, which you can access via Service Canada. And note that paper copies have been phased out, so you would have to do it online with Service Canada. The employee then takes this to Service Canada, and if you're issuing the ROE online, Service Canada will automatically receive it once you hit submit. Then Service Canada reviews the ROE information and decides what EI benefits are payable to the employee throughout their leave. For more information on EI, you can visit Service Canada at servicecanada.gc.ca. Next, the Federal Canada Labour Code and most provinces allow employees to take unpaid job-protected leave for family medical, also known as compassionate care leave. To qualify, the employee must need to care for a specific family member or someone the employee considers to be like family, who's at risk of dying in a specified time period. The employee must provide a certificate from a doctor to the company indicating the family member is at risk of passing away in the next 26 weeks. As usual, this leave varies per province, but in general, BC, Ontario, and Nova Scotia, for example, a full-time, part-time, or contract employee can take up to 8 weeks of unpaid leave in a 26-week period, and in Quebec, an employee can take 12 weeks in a 12-month period. In Alberta, the leave can be extended to 27 weeks. In all provinces, the weeks of leave don't have to be taken consecutively, and if the illness continues, the employee can reapply for more time. Since the leave is unpaid, the employee can apply for government EI benefits, and those are called compassionate care benefits while on leave. I'm sorry. I think I'm on the wrong slide. Something is going wrong with the slides. 1 second here. I'm just going to get the slides sorted out. I'm not sure if Sarah, if you can help me get the slides sorted out. I'll keep going. They just seem a little bit big for me on the slides. So the next slides address a common confusion. We often hear clients and employees confusing Ontario personal emergency leave with family medical leave. In fact, there are 2 different types of leave. Unlike family medical leave, which we just discussed, personal emergency leave is mostly unpaid job protective leave of up to 10 days each calendar year, and this includes employees who start halfway through the year. They would still be entitled to all 10 days of the leave. With Ontario's new ESA rules in 2018, employees who have been employed for at least 1 week will now be entitled to 2 paid days leave under personal emergency leave regulations. Personal emergency leave can be taken for personal illness or injury or an urgent matter relating to themselves or certain family members. To qualify, the medical situation does not need to be an imminent risk of death or to care for an ill family member. Also, prior to 2018, to qualify, an employee had to work for an employer with 50 or more employees, but with the 2018 ESA changes, this requirement was removed. And also the list for people for whom a family medical leave can be taken is not the same as the list specified for personal emergency leave. The list is more restrictive for personal emergency leave. Also, an employee can use this leave for pre-scheduled surgeries so long as the surgery is not cosmetic and is actually to treat an illness or injury. So we often get asked if an employee is entitled to leave even if the injury was caused by their own carelessness. And the answer is yes, they would be entitled to the leave if all other qualifiers exist. So be aware that an employee who qualifies for both leaves would have full entitlement to each leave and to the protections I discussed earlier. Before we move on from personal emergency leave, I wanted to review the definition of urgent matter a bit more, since this is the vague language in the Act that seems to get under an employer's skin the most. So an urgent matter is an event that is unplanned or out of the employee's control and raises a possibility of serious negative consequences, including emotional harm if not responded to. It's still a little vague, but examples of an urgent matter that qualify for the leave include an employer's babysitter calls in sick, or the house of the employer's elderly parent is broken into and the parent is very upset and needs the employee's help to deal with the situation, or the employee has an appointment to meet with his or her child's counselor to discuss behavioral problems at school, and an appointment cannot be scheduled outside of the employee's working hours. So those are all examples that are actually listed in the Act. Examples of events that don't qualify as an urgent matter would be if an employee wants to leave work early to watch his or her daughter's track meet, or an employee wants the day off in order to attend his or her sister's wedding or something like that. That would not qualify. So lastly, another common question we receive is how to integrate your employer sick day policies with personal emergency leave. The rule is that if an employment contract provides a greater right or benefit than the personal emergency leave, then the terms of the contract would apply. However, if the contract does not provide a greater right or benefit than the personal emergency leave standard in the ESA, the personal emergency leave provision of the ESA will apply to your employee. It's also important to understand that the Ministry of Labor will not get involved in determining how the leave provisions of the contract are applied. It's up to you as the employer to ensure that you abide by the policies you have in place, so long as they don't provide less than what the legislation requires. So for example, if an employee's family member passes away and you as a policy provide 3 paid personal days, and 3 paid bereavement days to your employee, the employee can use up all 6 of those paid days and still be entitled to 4 days under the personal emergency leave provision if you made it clear that the personal emergency days are covered by your bereavement and the personal leave days that you provide. However, if you don't make that clear, the employee might come back to you and say, hey, I took my 3 bereavement or my 3 personal leave days, but I still get another 10 personal emergency, 2 of those are paid. And it really is up to you as the employer to make sure your policy is clear so that you aren't entitled to provide all those extra days. Okay, sorry, having a little bit of problems with the slide advancement. So finally, to wrap up my section on leaves, Ontario has some unique leaves, some of which are new under the 2018 ESA update. So there's the domestic and sexual violence leave, critical illness leave, and they're both new. And Ontario also has critically ill child care leave and crime-related death and child disappearance leave. So hopefully no one ever has to use any of these. A summary of the legislation is listed on this slide for your reference, and we do have a summary which reviews all of the 2018 Ontario ESA updates at the end of today's presentation for your reference. So with that, I'm going to pass it back to Stacey, who's going to discuss drug and alcohol testing in Canada.
Thank you, Catherine. So drug and alcohol testing is rare in Canada, and in most cases, it's not worth the legal risk to do them. However, a previous Canadian case confirmed the following scenarios where drug and alcohol testing would be permissible. So firstly, in safety-sensitive positions where an accident or incident has occurred, as part of a post-treatment monitoring program in coordination with the employee, and as a condition of continued employment after a drug and alcohol policy violation has occurred. And finally is the pre-employment testing, meaning prior to an employee's appointment to a safety-sensitive position or pre-access to a safety-sensitive site. Safety-sensitive meaning being under the influence could cause irreparable damages or death. So the key to note here is that it truly has to be a safety-sensitive position or safety-sensitive site to warrant pre-employment drug and alcohol testing. And the testing would take place after the employment offer has been made to the employee. In some provinces, it's not the actual tests you administer that are discriminatory. You can do them. It's what's done with a positive result that raises concern for the Human Rights Commissions. Specifically, that you have to accommodate any employee you test that produces a positive result and is determined to be dependent on drugs or alcohol. So some things you should be doing to ensure you're not violating employees' rights include, firstly, having a solid and well-defined drug and alcohol policy in place, especially with the new legalization of cannabis coming into place later this year. This includes why you have it, who it applies to, how testing will work, what happens in the case of a positive result, employees' right to privacy, definitions, discipline, accommodation, and rehabilitation stipulations, and lay out what the employee can expect from the company and the company's expectation of the employee in regards to drugs and alcohol at the workplace. You want to ensure employees are aware of your policy. It's always a good idea to have employees sign off acknowledgement of your policies on a regular basis. We usually say yearly. Identify the risks of partaking in drugs and alcohol use at the workplace. For example, list the dangers to employees and their colleagues. And of course, if you can, assist however possible to prevent drug and alcohol incidents. So for example, try offering education sessions on these topics. If you're contemplating the adoption of testing as part of a drug and alcohol policy, you will need to take into account that the burden is on you, the employer, to show the courts that the testing is necessary for the job. You should also realize your obligation to demonstrate the reasonableness of the tests, and it is your duty to accommodate employees who fail those tests and are suffering from drug abuse or addiction problems, including alcoholism, to the point of undue hardship. So there has been some movement to randomize testing, but under very limited circumstances, and again, only safety-sensitive positions. The Toronto Transit Commission recently adopted random testing of its drivers, and over several months, 17 of 680 tests were positive, and the TTC has an obligation now to determine if those who were tested positive have an addiction that requires treatment and reinstatement, or if it was actually a breach of policy and to terminate. Also, note that, as I mentioned earlier, cannabis and marijuana is becoming legal in Canada in the coming months, so you may want to revisit your drug and alcohol policies to ensure you're still compliant. So in keeping with the medical theme, I'm going to now talk about the health care benefits in Canada. I often get asked by our U.S. clients why Canadian employers should provide benefits when Canada has public health care. And the truth is, although some services are covered through provincial governments, many benefits are not. Each province and territory in Canada has their own public health insurance plan. For example, in Ontario, it's referred to as OHIP, in Quebec, RAMQ, and in Alberta, it's Alberta Health and Wellness. I'll be referring to OHIP today to keep things simple, but each province's health insurance plan does cover different medical necessities, but overall they're very similar. As with most health insurance plans, OHIP doesn't cover any services that are not medically necessary. So for example, optional plastic surgery would not be covered. On top of that, public health care also won't cover most prescription medications, dental care, long-term disability, or eye care for most people. Again, there are variations between provinces and variations based on circumstances. Generally, the provincial plans will only cover regular and specialist doctor visits, government-approved immunizations, hospital stays and ward rooms, surgeries and emergency hospital care. For this reason, to remain competitive in the Canadian market, you should be offering a supplemental benefit plan for employees. Canadian employees will expect a benefit package as part of their offer of employment. A typical employer-sponsored benefit plan would cover the basic benefits not covered by that province's provincial health care insurance plan. So, for example, a typical plan might include medical coverage, so 80 to 90% of prescription drug coverage, semi-private hospital room instead of ward rooms, and paramedical services like massage therapy between $300 and $500 per year in person on the plan. For dental, usually 80% of coverage for basic dental treatments and 50% for major treatments up to a certain maximum a year. And a competitive plan will also offer vision care, long-term disability, travel coverage, and life insurance and accidental death and dismemberment at usually 2 times the employee's salary. Please keep in mind that life, dependent life, AD&D, and critical illness premiums and applicable taxes for those coverage paid for by the employer on the employee's behalf are a taxable benefit to the employee. And in Quebec only, medical and dental coverage that are employer paid are also taxable to the employee. We would be happy to recommend a great benefit broker if you're looking into a plan or you'd like to revise or save costs with your current plan. And an approximate cost for an employer-sponsored benefit plan would be between $200 to $250 per month per employee, depending on the coverages. This is really based just on a single person plan. That would be between $200 and $250. You can implement a waiting period for an employee to join your plan, such as a 90-day waiting period, which is very common in Canada. And also keep an eye out. The courts are currently reviewing cases for the maximum age 65, where some benefits will terminate for employees. They're looking at possibly extending that past 65, and that's going through the courts right now. And next, I wanted to review some benefit policy tips to help with your benefit policy creation. So you want to be sure to clearly detail the premium split. So for example, will your premiums be 100% employer paid, or will you split that premium 50-50 between your company and the employee? Next, you want to be aware that you cannot reduce or eliminate benefits without providing reasonable notice to employees. In my next section on termination, I'll talk about minimum notice requirements that can be used as a guide. You want to make sure you have a clear policy on how long your supplemental health and dental benefits will extend if an employee is off on long-term disability. Typically, Canadian companies will will keep an employer-sponsored benefit going until the employee starts LTD, so about 4 months or 26 weeks. Some employers will extend it for longer, 24 months, or even longer than that. But without a limit clearly indicated in the employment contract on how long your medical and dental will last for employees on LTD, you may be covering them for much longer than you think is reasonable, and you'll have difficulty removing them from the health and dental portion of your plan. Think about if the employee's doctor says they won't be able to come back to work again for a very long time. Be clear in your contracts when health and dental benefits will end for an employee in that scenario. And lastly, for an employee on sick or voluntary leave, you are allowed to pass 100% of the supplemental benefit premium cost to the employee. Again, be sure this is included in your policy upon hire and in your contract, so employees are aware ahead of time what is expected of them. And now Catherine will talk in more detail about the importance of the new hire agreement.
So when should you have an employment agreement in Canada? We say you should always have one. Canadian law assumes that employees retain all rights unless specifically contracted away, which is very different than at-will employment. However, contracts must also always provide for entitlement at least equal to the minimum standards under employment legislation. So for example, you cannot put in your contract that the employee will earn less than minimum wage. If you did put something like that or a lower than standard clause in your agreement, it would void the entire contract. It's common sense, but I'll say it anyways, as we surprisingly get a lot of people who accidentally do it in the wrong order and then get in trouble for it, but always give the contract to the employee and have it signed by the employee before they start the position if you want the agreement to hold up in court if it's ever challenged. Also, all contracts need to provide clear consideration to the employee in exchange for them entering into the agreement with you. An example of consideration is that the employee will receive a specific salary and benefits for the work that they'll be performing. It's also a great idea to make sure that you're providing updated agreements each time there is any consideration being provided to the employee. So for example, anytime you give a raise, bonus, promotion, or other change in order to keep your contracts up to date. Courts will not rely on old contracts from 10 to 15 years prior, especially if any employment conditions have changed since the original signed agreement. Also, always provide a reasonable opportunity for the candidate to review and or seek legal advice regarding the employment agreement before they sign. So this is just a slide that shows a lot of different clauses that you may include in your employment agreement. Obviously, some are meant for more senior or executive agreements, so it really is just a reference tool for you. There's a lot to consider with regards to compensation in the employment contract, but here are a few that often get overlooked. Ensure you've addressed all direct and indirect forms of compensation, so bonus structures, commissions, incentives, benefits, vacation, etc. Also, consider all other compensation as well, so things like membership dues, association costs, and location costs for moving at the company's request. Also, how will the entitlements be dealt with upon termination? Clear language must be used to ensure it's understood when exactly rights to entitlements will end when the employee is terminated. So for example, final commissions will be paid once invoices are paid, or year-end bonuses will not be paid if you're not employed with the company at year-end, or benefits will cease upon termination, etc. It is important to let employees know upfront what will happen upon termination, and Canadian employees will expect to see this in their employment agreement. Next, I'm going to briefly touch on restrictive covenants. Common law in Canada does recognize the duty of employees to protect and maintain the confidential information belonging to an employer. However, by putting it in your employment agreement, you are explicitly informing employees of their obligation as well as clearly defining what you consider and expect to be treated as confidential material. Like in the U.S., non-competition agreements are generally unenforceable in Canada unless they're super concise in terms of geography and length of enforceability, and the agreement is only protecting vital information. Sometimes a non-solicitation agreement is more appropriate. The law in the area of non-solicitation is always evolving, and again, the restrictions must be found reasonable in terms of length and geographic scope. Just ensure you use appropriate language in your non-solicitation. So for example, use the words non-solicitation, because if it looks too much like a non-compete, it will probably be too broad and be unenforceable. On a final point, you should never use a blanket restrictive covenant clause. Always tailor the clause to the nature of the position's job duties and the specific employee in question. As for termination clauses, and just to note that Stacey will be discussing termination shortly, we recommend limiting with specific language the amount of termination pay the employee will be entitled to. So for example, limiting employees specifically to the employment standards minimum requirements. Outside of Quebec, this language will help limit your financial exposure. You can be creative and add your own termination clause in regard to a fixed entitlement or formula based on years of service, so long as it goes beyond minimum standards, and be sure to add the duty of the employee to mitigate. Finally, you'll also want to consider short and long-term disability coverage and when those will end. Recent cases have determined that employers are on the hook for LTD during notice of termination periods where not stipulated in the employment contract. So make sure you've confirmed with your benefit carrier how long your employee's benefits coverage will last when they're terminated, and adjust your offer letter of employment accordingly. Other things you should consider in your termination clause is what happens if the employee resigns. How much time do you want for them? Or what will be the employee's probation period? So it's generally 3 months without notice being owed. And finally, you should list the circumstances where termination will result without any notice or notice pay, referred to as a just cause. And on that note, I'll pass things back over to Stacey to discuss terminations in Canada.
Great, thanks, Catherine. So the terminations are an unfortunate necessity at times, and I'm going to start by probably surprising a few of our listeners today by saying there's no such thing as at-will termination in Canada. Instead, a notice of termination must be given to employees, including temporary, contract, and student employees. And as usual, the minimum employment standards vary provincially unless there is cause for the termination, which I'll discuss later. To answer a common question first, when an employee terminates, an employer must provide a written termination letter and a record of employment known as the ROE that Catherine had discussed earlier. This document generally has to be provided within 5 days of the termination and is usually done by your payroll provider or through the ROE web. You should also be aware that different provinces have different stipulations on when the final pay must be deposited. So when you are terminating an employee, you can choose to provide working notice or pay in lieu of notice. Working notice means that you can tell the employee on a Monday that effective immediately they have 2 weeks left of work before their employment terminates. This is done when there's no real security concerns. Versus pay in lieu of notice, which means that you can tell the employee on a Monday that his or her job is terminated effective immediately, but the employee will get a lump sum payment in lieu of actually working the notice term or those 2 weeks. Generally, the minimum standard is, but again, it depends on the province, that the employee gets approximately 1 week of notice for each year of service to a maximum of 8 weeks. Also, on top of this, Ontario legislate that for employees of certain seniority, a lump sum severance payment based on length of service must also be paid on top of notice pay. In Ontario, for this to be true, you have to employ more than 50 employees and have a payroll of over 2.5 million in Ontario. When terminating an employee, all outstanding vacation pay must be paid and the employee's benefits maintained throughout the notice period. This means the statutory notice period as well as the common law period if your contracts do not stipulate otherwise. Also, as an aside, but I feel it's important to mention, if an employee provides you with 2 weeks notice that they are quitting, and if you, for security or other reasons, ask the employee to leave immediately, you are still responsible for paying the employee through their notice and to continue benefits until the end of the notice period, unless you have a clearly worded clause in the employee's offer stating otherwise. And lastly, you cannot change any conditions of employment during the termination of notice period. So for example, you can't decide that because the person is leaving anyway to reduce their hours or responsibilities. Next, and distinct from minimum employment standards, but extremely important when you are determining the appropriate notice to provide to a terminating employee, is common law. So common law is based on legal precedent and increases the notice periods that should be given to employees. So for example, for many high-level positions, common law practice may be to provide around a month worth of notice for each year worked instead of a week. However, in Canada, you have to treat every termination as unique and handle it accordingly and as consistently as possible across your company. So tied to common law notice are the individual characteristics of the particular termination that you're dealing with, which will also affect how much notice to provide. For example, if you are terminating a 59-year-old product specialist who's worked at your company for 30 years, notice of termination would be above a month of notice per year of service, since it's obvious the employee would have difficulty finding a comparable job due to their age and because their career has been so focused on your specialized product. This employee would need a termination payout equivalent to several years' worth of service. Overall, when terminating an employee in Canada, you must pay attention to minimum notice standards, common law, and those list of specifics you're facing. In many situations, it's wise to get legal advice since common law precedent is changing all the time. Although very rare in Canada, notice and severance pay does not apply if an employee is terminated for cause. So for cause or just cause termination means that no notice or severance has to be paid. It occurs when the employment relationship is severed because the employee has committed fraud, theft, or willful misconduct. Be cautious. For-cause terminations are very difficult to prove, and you must ensure you've documented and have concrete reasons for it to hold up if it gets challenged. So for example, performance problems would be very difficult to justify as a for-cause termination, even with documentation. Overall, it's advisable to have a consultant or a lawyer confirm you're taking the appropriate actions before terminating an employee for cause in Canada. Now we'll go from talk of terminations to discussing the beginning of the employment process, recruiting tips and trends. So the first part of screening any candidate after reviewing their resume is the interview phase. In Canada, employees are protected by our human rights legislation, provincially and where applicable federally. So like in the U.S., they're protected against discrimination in hiring decisions. You can't discriminate based on race, national or ethnic origin, color, religion, age, sex, sexual orientation, the list goes on. So to avoid issues of discrimination in your interviews, there's a few important measures you should put into place. Firstly, avoid misrepresentation. Don't overstate the position. So for instance, there's documented evidence of a lawsuit where a company said that they would give an employee a job for life, and that was actually taken into account on a termination decision, and the employee was awarded more just because of that wording. So avoid misrepresentation. Number two, ensure that all candidates are asked the same questions. By doing this, you help eliminate the candidate's allegation that they were treated differently. You want to ensure that you do not engage in idle chit-chat regarding marriage, kids, religion, or other protected grounds. Although it seems like innocent banter, it's all too easy for an unsuccessful candidate to allege that you didn't hire them for one of those protected reasons. And it would be up to you as the employer to provide proof to the courts that you didn't actually discriminate against them. And finally, document everything. Document decisions for hiring or rejecting candidates, and make sure that they're legitimate and job-related. Many of the clients that we recruit for have asked us for the best posting locations in Canada. This is just a list that you might want to try if you are looking for someone. And recently in Ontario has also implemented legislation under the Accessibility for Ontarians with Disabilities Act, known as the AODA, and under the employment standards that requires employers to notify candidates about the availability of accommodation during recruitment, provide assessment and selection materials in an accessible format, and notify successful candidate of the policies for accommodation of employees with disability. And now I'll pass it up to back to Catherine to finish up today's webcast and a review of some mandatory trainings.
So switching gears slightly as we're wrapping things up, I'm going to highlight the mandated employer trainings in Ontario. Ontario is the strictest province for mandatory trainings in Canada. So in Ontario, and it's best practice in other provinces, employers must provide training to employees on workplace violence, harassment, and sexual harassment, which was introduced to address workplace harassment under the Occupational Health and Safety Act. So employers are obligated to have a violence, harassment, and sexual harassment program and policies in place that outline clear procedures and an investigative process for handling complaints. So employees must be made aware of this information and the policies, and they must be trained on workplace violence, harassment, and sexual harassment prevention. Non-compliance can result in Ministry of Labor penalties. There's also what Stacey just mentioned, the Accessibility for Ontarians with Disabilities Act, or AODA, training. And this must be done with all employees, and the main component of that is training them on customer service standards and employment standards when it relates to anyone visiting the workplace with a disability. Lastly, the Ontario Occupational Health and Safety Act also mandates health and safety awareness training for all employees and supervisors for health and safety in the workplace. And there is some online training provided by the government, and HR Options also provides all of the above trainings. If you want to reach out or have any questions, please feel free to contact Stacey or I. And as I mentioned a little bit earlier, the next few slides, I'm not going to go over them. I'm just going to kind of click through them so you can see them, are slides that highlight the Fair Workplaces, Better Jobs Act that went through the legislature in 2017 and took effect in 2018. So it kind of shows what the former legislation was and what the update is. So it goes through each category. And on this slide, there's a link to the Ontario changes. And I also included a link if you have people in Alberta, because they also had a lot of changes in 2018 too. And just know that everything Stacey and I covered in today's webinar covered the updated changes. So to wrap things up today, oops, I'm having trouble with my slides again, I'm so sorry. I will just pass it right back over to Stacey with our final slide on employment options in Canada.
Great, and thank you, Catherine. So now that you're more aware of the various legal complications and legislation, and you're excited to get your first Canadian worker on the ground, I wanted to review some options that are available to you in Canada. So one, of course, is to hire an independent contractor who by definition is self-employed. So this does remove a lot of the tax deduction and remittance responsibility for you, but you just have to be very clear that they are truly an independent contractor, because if they're not, similar to the US, you will face penalties if they are not actually, if they truly are an employee. You could always go around by setting up your own Canadian entity in Canada, and this means getting that Revenue Canada business number, as well as setting up with workers' compensation boards and understanding, of course, all those legislations that we talked about earlier today. A final and more feasible option might be employing a Canadian would be to use outsourced or third-party employment, such as HR Options. In cases where you do have a project to be done in Canada, or you have an amazing employee in the US who's moving to Canada that you wish to retain, or perhaps you just want to test out the Canadian marketplace, but you don't want all those administrative hassles of dealing with the Canadian government, or don't have time to understand Canadian legislation or Canadian human resource processes, a third-party employer can help your employees in those situations for you. A reputable outsourced employer will take the burdens of Canadian employment, payroll, group benefits, group RRSP comparable to a 401k, and human resources management of employees off your hands so you can focus on your business. The employee performs the work for you, and the outsourced employer handles all aspects of employment from beginning to end. This reduces liabilities like those IC misclassifications and eliminates the potential for penalties or filing taxation incorrectly. HR Options can employ Canadians doing work for your U.S. company or U.S. employees coming to work in Canada. We also have an office in the U.S. which provides third-party employment and consulting services. So please be sure to reach out and visit us at www.hroptions.com or .ca. If you're not set up already,